global compliance, and e-discovery for Archive 360. Bill spent almost 3 decades helping organizations develop their strategies for archiving, information governance, and e-discovery. He's a frequent speaker at legal and information governance industry and published author, excuse me, governance industry events, and a published author, including The Know-It-All's Guide to E-Discovery, The Bartender's Guide to E-Discovery, and Cloud Archiving for Dummies. Our next speaker is James McCarthy, Chief Compliance Officer and General Counsel here at Archive 360. Prior to joining Archive 360, Jim served as General and Litigation Defense Counsel for 25 years in private practice, working with corporations and local, county, and state government bodies. Jim is an adjunct professor at Felician College, teaches employment and business law, cybersecurity, and ethics. And finally, a quick word about Archive 360. Archive 360 is an intelligent information platform trusted by organizations around the world to securely migrate their digital data to the cloud and responsibly manage it for today's regulatory, legal, and business intelligence obligations. Our customers achieve this by applying context around the search, classification, and analysis of structured and unstructured data, including files, videos, audio, CRM, ERP, emails, electronic communications, and social media, all while maintaining full control over security, privacy access, and compliance. Now that we're finished with our introductions, I'd like to turn things over to Bill, who will begin with today's agenda.
All right. Well, thanks, Sharon, and greetings, everyone. And good to talk to you again, Jim. What we're going to be, everybody can see the agenda. Basically, the key takeaways that hopefully you will recognize today in the webinar is it really comes down to having to know what your company's responsibilities are when dealing with privacy deletion requests. And, that sounds rather, kind of obtuse, but as we get farther into the content here, you'll understand why. And obviously, based on the title of the webinar, it all revolves around, the privacy laws and especially the right to be forgotten, and how personal information that's backed up onto backup tapes. How is that affected by that right to be forgotten? And I've talked about this a lot at conferences and so forth, and it really is an issue that a lot of companies are facing and really want an answer to. And then based on that, what are the possible workarounds for dealing with PII on backup tapes? And how do you respond to a PI deletion request? What are the expectations? What are the regulatory expectations? A lot of this stuff is not necessarily down in black and white. So both Jim and I will talk about it a little bit more. So let's talk about some of the key challenges before we get into the actual meat of the discussion. And really the key challenges revolve around what are some of the key challenges companies are facing when new privacy laws, especially the right to be forgotten, are becoming much more, number one, known by lots more people, but also the question basically surfaces, and we just had somebody yesterday bring this up. How does this the right to be forgotten and collection of PII by companies and so forth, how is that being how's that being handled with all the stuff going on with COVID-19 and this idea of tracking and all kinds of other stuff? I mean, it seems like they're mutually exclusive. So we need to let's keep that in the back of our minds. And then how should PII on backups be addressed? Because the standard way of backing up in most organizations is, you do a complete backup of server, and it has everything on it. It has the operating systems, the log files, the DLLs, all that kind of stuff, as well as the files. And files are where PII is kept. So, how do you do that? is it possible to actually address it? And then another challenge is backups going back many years, and I know a best practice for backups is you recycle backup tapes, and we can get into that further down if we have time, but what and by the way, most companies don't do that. I mean, in reality, Iron Mountain is full of probably hundreds of millions of backup tapes that companies have kept, going back 30 years, for example. And what's the expectation there? And then really, the underlying question is, can PI or PII be truly forgotten? And that's a really interesting discussion that we don't have time to get into very deeply here, but it could be an 8-hour discussion. So it's really quite interesting. So with that, I'll turn it over to you, Jim.
Thanks, Bill. Hi, everyone. Bill, it's good to be speaking with you again. So the topic for today is the right to be forgotten, but with any luck, we hope that some of this will stick with you after the webinar. So let's jump right in. First point is digital privacy rights. And what we mean by this is that governments around the world are recognizing formally that now we live a significant portion of our lives online. Everything from banking to consumerism to our communication with our business and our families. And legislatures are now recognizing that while you're online, you have certain rights. And this is the underlying principle behind these new laws that are coming about. So, Bill, let's get into some of the new laws for the next screen.
Well, Jim, one quick thing, and we talk about the rise of digital privacy rights, as a fundamental human right, and how far are those going to go? And I know you and I have talked about this before, but earlier in the year, New York had a proposed privacy law in their state house
Legislatures, yeah.
Yeah, that basically floated the idea of data fiduciaries. And after reading a bunch about it, the idea of companies that handle PII having to follow the data fiduciary requirements, it really is that. And by the way, it was called the New York Privacy Act. It required companies that collect data from consumers to act in the best interest of the consumers, rather than the business. Yeah.
Right. It's much different than a repository. A fiduciary has affirmative obligations to those customers, which are high hurdles to match.
Well, yeah. You imagine the litigation that would come from something like that. By the way, that law with that data fiduciary requirement was stalled out in the legislature, and I think this concept is going to rise to the top in a lot of state and even federal laws. But something like that would just generate so much litigation, because who's to say what was in the best interest of the data subject?
Yep, and we're seeing that play out right now with the social media platforms, whether or not they're going to be responsible for the content that's placed on them or not. But
good point.
That will be, I'm sure, something for a future webinar by us.
That would be a great webinar here. Yeah.
All right. Yeah, and so what we're seeing is that we always reference these two because they're most identifiable. But the European directive GDPR and the California counterpart, the Privacy Act, are just the first of many new laws that exist or in legislatures around the world presently. But they all speak to the same thing, which is that fundamental privacy right, which is the right to be forgotten after I have exposed some information online. All right, so again, that right to be forgotten, what does it really mean? It means just that. It means that companies are obliged to go back and erase certain information that individuals and companies place out in the public domain online. And they have to do so with some degree of speed and efficiency, meaning that they have to get all of the data, even the data that resides on copies and backups and things like that. So this is going to be a sore litigation point. in the future. But,
well, and Jim, one of the other repositories that has always been an issue is all of those individual workstation desktops that employees use, and somehow they get access and have, potential PII and all those things. And how can IT go and find all of that stuff and make sure they got it? If you get a request for erasure, and they check all of their active systems, say, yeah, we got it all, and then 2,000 of the employees have the PII on their workstations, obviously you have an issue. But yeah, it includes all copies. And then this is, Jim, this is a question you and I have talked about a lot. What's the intent of the right to be forgotten? And it's obviously erasure of PII, but and we won't talk about it here, but I just wanted to raise it.
Absolutely.
Is a standard computer soft delete good enough? Is it unrecoverable? And I think I've talked to attorneys and regulatory people and asked them that does the deletion, and even analysts, does the deletion have to be unrecoverable? And they all scratch their head and kind of look up at the ceiling and then say, I think so.
Yeah, you will find varying degrees of definitions of what erasure means in different laws, and this is going to be one of the many variables in the different jurisdictions where this will apply.
Well, and the basic question is, if the intent is the right to be forgotten, but you can recover the data in 10 seconds, have you been forgotten? Again, this has not been addressed in the body of either of the laws, so it's an open question.
Bill, can I jump in for a second?
Sure.
We have a question that just came in.
All right.
Does business PII, business client contact information, equate to personal identifiable information in terms of need to erase/forget? Can you comment on how business PII right to be forgotten is treated when business contacts are needed for basic business operations, including incident management, billing, account management, etc.?
Well, and Jim, obviously, I think, yeah, that's probably your question, but the question is, and I think there are, provisions in the laws that basically say, if the data subject is an actual ongoing client, then possibly the erasure request is not valid. What do you say, Jim?
Yeah, for example, California has a number of exemptions to this obligation. Exemptions like if the information is needed to complete a transaction, if the information is needed by an employer to protect against a statute of limitations from an employment claim, things like that. But the question had an interesting twist at the very end. But what if I simply need the data for business purposes, for marketing, let's say, or to continue? There is no generic exemption. There are specific exemptions in California and GDPR, but not a generic catch-all that can be used to work around the intent of the law itself.
Well,
but there are many of the exemptions, though, are broad in California, and you will see people retaining that data and relying on some of those exemptions to justify it.
And the two broadest exemptions across both privacy laws are, you don't have to do it if you have to keep the data for some length of time for regulatory retention requirements such as SEC or MiFID II. And then the second one is if it's potentially involved in litigation, as a legal hold or something like that, then that data obviously can't be destroyed until the case has been settled, right?
Right. And Sharon, if there are more of these, I like the live questions and fielding them. It makes it so much more interesting. So keep them coming. All right. One of the questions that we either expected or received or got some feedback on is the recent situation with COVID-19, Corona, however we call it lately. How will these affect the new privacy laws? And this is going to be a very interesting dynamic because at its core, COVID-19 reactions by governments will include something called contact tracing. basically getting very personal information, health information about people, and using them as a means to flatten the curve, to slow the rate of infection. That is, of course, directly contradictory to our notions of privacy. And these two dynamics will soon meet up, and which one will yield? Usually it's the issue of the day that yields to the underlying principle. So my sense is that emergent police powers of the state will permit this type of contact tracing, even if it runs afoul of some of these privacy laws.
Well, and that's you know, some of the articles just in the last week or so we've been reading you know, out of Europe about the various country data protection agencies that rely on GDPR are hinting that they may not be you know, actually enforcing GDPR during COVID-19 because of those specific tracing requirements.
And as we know, Bill, it's not a singular privacy law that governs GDPR, but in fact, each of the the 27 now member states, each have their own data protection agencies, and their laws vary. So again, this is just going to be something for the practitioner to keep in mind, that there's going to be 27 different sets of laws, and all of them may or may not be impacted by COVID-19 legislation.
Yeah.
Yeah, so let's get into the fun part. So your enterprise has committed a violation. What kind of exposure are we looking at? It's important to know that the California, that's the CCPA, by the way, the California privacy law is, you know, was passed, but it wasn't effective until this past January. And so I don't believe it's going to be enforced at least until July, if not extended further. But this is pretty severe penalties. It looks modest, $2,500 per violation, but understand that's per consumer account. For example, the Capital One breach affected 106 million accounts. When you start doing that math, then you can see that the potential fines, the potential exposure for large companies is significant. It also has an interesting dynamic that the other laws may not have, which is an individual right of action, not by the state's attorney general, but a private right of action for account holders for certain types of breaches. And it is significant also because it presumes damages. Mm-hmm. You may remember, Bill, there was a case, the Dolly Madison case many years ago, in which a site for married people to connect with other people outside of their marriage, that database was hacked. And as you can imagine, there were a lot of nervous spouses out there. And what happened is that the breach never resulted in people being threatened or extortion or things like that. In fact, it was, by all accounts, never really published by the hackers. But they claimed that there was a potential of damage, and that should be enough for this lawsuit to continue. Interestingly, in that case, the lawsuit did not continue because there was no presumed damages. California changes that. It presumes a damage by virtue of the breach itself. Yeah. So there doesn't have to be any use of your information, Bill. Simply the fact that your information was hacked is enough for you to file a claim.
Well, and another interesting aspect of the California law is that there's now a new law on the California ballot for November. A lot of people refer to it as the CCPA 2, but officially it's called the Consumer Data Privacy and Security Act of 2020. And there's nothing earth-shattering in it like the first CCPA, but it just shows that this is going to be an ongoing trend, at least in California and probably in a lot more. But there is a new bill in the federal Congress. It's called the CDPSA. It's called Consumer Data Privacy and Security Act of 2020. I'm sorry, that wasn't the California law. The second California law is California.
It's hard getting all these acronyms straight.
I know it's going to be
A very interesting part of what you raised, though, is a federal law, which doesn't yet exist, but it's always put to us, what impact will that have on these myriad state laws that exist? And it's interesting because the concept of federal preemption would apply, meaning that if there's a federal law that is in place with the same subject matter, it could, being operative word, have the effect of eradicating California's law, Tennessee's law, and all these other states' laws.
Well, specifically on this draft bill in the Congress, it does actually have a provision that says express preemption of state law. So that, yeah, it would preempt all state laws, which obviously probably would not make California too happy. It also has some interesting provisions as well that the FTC, the Federal Trade Commission, would actually administer it.
And it makes sense, though. I mean, when we think of this California Act, and I know it says it only affects California folks and transactions, but understand that California is something like the 5th largest GDP on the planet.
Yeah.
So companies all over the country, indeed all over the world, deal with California residents and California people, and all of them are subject to the CCPA if they expose themselves to that jurisdiction.
Yeah, worldwide.
So having a national statute rather than this fabric of piecemeal by each state makes sense. Let's see if we can get their act together, though.
And one last thing on the federal law, and we'll move on. Section 5 of the new federal law would grant consumers individual control over their data. Covered entities would be required to implement privacy controls that provide an easy-to-use means to exercise individual rights, under it, including the right to be forgotten, the right to deletion. So, I think the main subject, what we're talking about today, is going to be, in almost all the new privacy laws, the right to be forgotten.
Right. What's your opinion? Oh, this is
Oops.
Yeah. No, that's
yeah,
it.
no, and the other thing I was going to say, Sharon, I think we got another question, didn't we?
I have a question that came in. With all of these privacy laws in some state of early implementation, what do you recommend companies do now to be protected, like a baseline starting point to have a protection in place?
Well, let me preempt that. Yeah, let me preempt that. We do address that further on, but that's a great question.
Yeah, so if the person asking the question could hold on, we should and will get to that.
Yeah. Yeah.
We had one more question in. Is it the company's responsibility to track residency either by state or by country?
Well, and Jim, jump in too, but in my mind, if you're a company that is collecting data for marketing, obviously you're going to collect their state and city of residence. If they move from there, that by the way, that's part of validating the request when it comes in. Do you still live in California, or do you still have the protection of this law?
Yeah, but the question is somewhat blunted by the fact that it's very difficult for companies to put in two different systems, right?
Yeah.
I have a system for all my California consumers, but I have a different system for my Oregon and my New Jersey and New York consumers. They probably wouldn't do that. So they probably would put in place the system that complies with the most stringent law out there, which is
a high watermark, yeah.
Which is all these states are trying to one up the one before that and make even more protection.
Yes. Yeah, no, that's a great point. Yeah, I think most companies, especially the medium to large, are going to basically take a high watermark strategy and say, like you just said, whichever one's the most stringent, that's the one we're going to follow for everybody, because it'll be less costly.
Sure.
Yeah.
One more question before we move on, which I know we'll leave time at the end, but we're going to take questions now anyway. When GDPR came into effect, a number of companies, including news outlets in the USA, used geofencing to exclude EU access in order to obviate the need for dealing with GDPR. Do you believe that California and other global laws will produce further exclusions to global citizens to prevent the need to worry about people outside their home state or country of the
Yeah,
company?
that's actually that's a really good question, and the idea is, we talked about this early on as well. The idea is, well, gee, for example, Canada has a very, very strict anti-spam law, and do you basically not allow or don't collect Canadian PI so that you don't inadvertently break that law. And here, I think the question is good. Do you think companies will basically not accept California or EU, PI? I mean, that's possible, but I don't see it happening because there's such big markets.
I don't see it happening either. I know we got to move on, but I think commerce will go over the idea of that fence. They will flow right over the fence.
Yeah.
But, all right, so we have these ransomware and privacy rights. This is also going to be the subject of some more separate webinars, Bill. But we can see the examples here. What happens? The question is, what happens when the system is breached, and then there's a threat to expose the information if a ransom is not paid? Does this violate the privacy laws? In a word, I mean, we may differ on this, Bill, but I think yes.
Well, I think you're right too. And in fact, I just wrote a blog on this for the Cybersecurity Tech Accord group and posed the question. And I think, Jim, you and I talked about it a while ago. But these new forms of ransomware, besides just getting into your system and sitting there for a period of time. And by the way, while they're sitting there for maybe months on end, you're backing them up and all these other kinds. You don't know it, but all of a sudden you got 100 backup tapes with this ransomware on it. So you can't restore a good backup tape, which is one of their strategies. But their strategy is to trigger at some point in time, encrypt all the data they can within the enterprise, and push up a little note that says, by the way, you're not going to get the encryption keys, to unencrypt all this unless you, deposit 100 grand in Bitcoin. But these new forms of ransomware go one step further, and besides encrypting the data, they steal it, move it to their own servers, and then part of the threat is, and oh, by the way, if you don't pay us, we're going to release all of your data unencrypted on the internet. So the question is, by the way, I mean, there would be huge amounts of PII in that data that was released. Would that company who was hacked be responsible for violating GDPR and CCPA privacy rights? And I think, like you said, Jim, I think both of us agree that absolutely, because you didn't have good enough security to stop the original hack from happening.
Yeah.
So, and by the way, I could imagine shortly, receiving a ransom note that basically says, hey, you're never going to get access to the data again. And by the way, we're going to release your unencrypted data on the internet. And then we're going to give a heads up to the GDPR and CCPA that says, look what these guys just allowed to happen. And oh, by the way, 100 grand in Bitcoin is a lot less than 20 million euros. So,
right.
Yeah, an interesting question there.
So it begs the question. I think it's sort of understood personal information, but the takeaway should be that this personal information is expanding. The definition is expanding all the time. It's not your name, date of birth, and social anymore. We call it attributes or PII. And some examples of them you could see here next to Homer, but some things that you wouldn't necessarily immediately think of as your attributes is covered by this legal framework. Things like your gait, how you walk, how you speak, your voice pattern, genetic data, your thumbprints, biometric data of all types. Even as Bill, in one of these articles that you mentioned, your scent, which is unique to you. These are all biometric data points that are protected under GDPR and some of these other privacy laws.
Well, and Jim, like we've talked about before, there what was it, a half a year ago, the scientists developing the code.
This was a very interesting dynamic in which some data scientists from Europe figured out a way to identify who you were by using as little as 15 attributes. And
By the way, out of 255 recognized personal attributes.
right,
So
now it used to be about 250 attributes were sufficient to identify who we're talking about. These data scientists were able to cull information and do data mining to the point where if you just give them 15 attributes of very irrelevant information, you would think, they can identify who we're talking about.
Yeah, they have a 98.8% accuracy rate.
But they were even more than academic, though, Bill. What they then did was they published the software and the code on how to do that, just to force the industry to get better at anonymizing your data. So what we now think is data is anonymized because we got it down to 255 attributes, not so much. So they forced the hand of companies to build a better mousetrap.
And by the way, if you're interested in this specific story, we have 2 links listed on the slide that you'll get copies of that you can read about it. But it really is scary, the fact that they released it. So
this begs the question: can I really be forgotten? Can I really comply with this law, or is this some sort of legislative mandate that really can never ever be truly complied with?
Yeah, and I agree with that. By the way, I don't think in today's world, today's technology, you can never guarantee, a company could never guarantee, or a set of companies can never guarantee that all of your data is gone and unrecoverable. I just don't see it happening. But I think part of it is the intent of trying to do it correctly and then documenting what you did. Hopefully that would at least lower the fine somewhat.
Yeah, towards compliance is usually what you would look to when you're defending something like this. You know, if complete compliance is not practical.
Good faith attempt goes a long way in most judges' eyes, right?
Yep. So show us how to do that, Bill.
Brings up the question: what about backup tapes?
So the debate rages on. Is backups covered by this, or is it just your active system?
Yeah, and that's really interesting. And you know, I think I stated in another slide here, but the whole question of what about backup tapes are not really addressed in either of the privacy laws. And I skimmed through the new federal draft, and I didn't see it in there either. So that brings up the question, you know, that we've kind of hinted at here for a half an hour. You know, what about PII on backup tapes, and what's the expectation? And you know, in one of the slides Jim was doing, you know, or maybe I haven't gotten to it yet, but it really comes down to, you know, what was the intent of the privacy laws? If the right, you know, to be forgotten, if the intent was actually you need to be forgotten, then PII sitting on backup tapes for 6 months to a year, you're not forgotten. So let's quickly, you know, look at this. The issue is there are so many different applications, repositories within an enterprise, and these are all active systems. And you know, this is not easy, but you know, active systems, at least you can go up and query them, find specific, you know, data, you know, entries and stuff, and do an erase. You know, it brings up the question of secure or unrecoverable versus recoverable, but that's another total subject. But you know, it's not easy on the face of it, and in reality, what that means, and I've you know, in my consulting days, I've worked with companies to you know, do this sort of thing, even pre GDPR, and really what it involves is going to each one of those systems using probably an included search capability. So each repository is going to have a completely different search capability, probably with different logic and all kinds of neat stuff. But you got to go to each repository after you've validated the request and search for that PII. Basically tag them. Maybe you know, put them on a hold so you know, go get verification somewhere, but eventually you delete the PII from each and every system. You know, the big question, you know, is in this case, did you miss a repository? or a desktop. And like I said just a little while ago, if an employee took a database and is sitting on their local laptop so they could work on it, individually, maybe while they're travel or something like that, I mean, that's still PII potentially. And during your erasure of based on this request, did you go to all the various, remote repositories? And that's a big question. And if you didn't get them, then you're in violation of the law. There's no excuse. And really what this also does is it forces companies to get much better control of their data. Up to now, companies worried about regulated data, which was usually in the 5% range of all data within a company. But you got that other 95%, which includes, drafts of things with people's names in it, maybe their emails and all these other kinds of things. And that's all over the place. So companies, to lower their risk, are going to have to get much better control of all of their data, not just their records. So let's look at privacy rights versus backups. And like we've said a couple of times, the right to be forgotten covers all copies of PI, no matter where they're maintained, except where legal and regulatory options, exist and can supersede the request.
And we expect that the exceptions bill will be a minority of the overall data sets that we're talking about.
Yeah, I mean, you have to ask yourself, if for example, one of the big Wall Street banks gets a request from one of their customers saying, I want to be the right to be forgotten. I mean, how many people that are in the financial industry, aren't trading, through the big banks, are going to want to be forgotten immediately overnight? So it's probably not going to be a big deal. It's the financial sectors and a couple of the other regulatory industries that are going to have to deal with this. But it is, what does the right to be forgotten requirement mean for company backups? And again, like I said, that hasn't been addressed.
It hasn't, but we expect, Bill, the first test case will side with the privacy of the individual making the request, because if backups are not covered by these laws, then you truly can't be forgotten in the manner in which these legislatures wanted it.
Well, and that's a great point. And the other thing there is that maybe they didn't think they needed to address backups because PII and all of its forms need to be deleted. The authorities probably didn't understand what the cost and the issues would be. And I could foresee some non-technical people writing the laws not thinking that's a big deal, but obviously it is. And I had an email conversation with a couple of law firms in Europe, and one of them responded back saying, that this is not their comment to me, but basically they said, I've heard regulatory authorities say, what don't you understand about all copies? How is this a question to you? Yeah. But others have said, probably just as good of people, law firms and so forth, have said, no, that's not realistic, and I think they'll give them a break. So again, there's no precedent on it. There's no decision. So this puts companies at a real disadvantage. What do you do between now and when the laws change or a precedent set? And like Jim will agree.
On the other side of that, when the attorney or particular agency regulator wants to make some law for themselves, or or get a third contingency of something.
Yeah.
We have a question that came in, if I can interrupt. Really, one question, and then someone else made a very poignant comment, and I wanted to pass it on. So this is a case of legal bodies not understanding the technical impact of deleting data. I just thought that was very
well, and I think it's not just legal bodies, but also the regulatory bodies. Those. I mean, and Jim, jump in here, but that's a great comment, by the way. But lawyers, in the ABA professional bylaws, have a couple of lines in there that says, lawyers, are expected to know enough about the technology to not make mistakes based on it. but for the regulatory bodies, there's no such requirement professionally. So I'm sure some of them are great and some of them are not so great.
Yeah.
But that's a great comment.
In virtually every area of technology, technology companies have outpaced legislative attempts to catch up with them. Will be no different here. And the first efforts that we see, like GDPR, California will have shortcomings, and these laws will get better over time. And I think that's probably why you see some delay in the federal model. They're trying to get it right.
Yeah. Well, and that second question, Sharon, how does a litigation hold requiring preservation of evidence impact the obligation to remove PII? And in reality, it supersedes it. If there's
meaning
legal,
the litigation hold supersedes.
Well, I mean, even in anticipation.
A legitimate hold throughout the applicable period of statute of limitations would trump that.
Exactly. Yeah, and both laws have that written into it. Both regulatory requirements as well as legal requirements supersede the right to erasure. Okay, so let's get back and take a quick look. We saw this before. I won't go through it again. But what does that mean for backups? And it's a little bit more involved. And in reality, you get the request, you determine the validity of the request. Then you start going through your tapes and you search. You basically, have to restore each tape to a blank server, get it to that point, search it for the PII, delete the PII, do a restore of that server so you have that backup tape again without the PII on it, and then you go to the next one. And I know customers. I dealt with a large healthcare organization that had 1,800 tapes at any point in time, and they were constantly spending a fortune just restoring them for e-discovery, much less the right to be forgotten. So it really is very involved. And oh, by the way, I mean, on the legal side of the business, just the cost to restore and search a backup tape, not to re-back it up again, but just to restore it into a search, according to the ABA a couple of years ago, it cost anywhere from $1,000 to $2,500 per tape, with all the overhead and all that kind of stuff. So you can imagine if you got 100 or 1,000 tapes, that's obviously going to be a cost issue for the company. Interesting slide here, Jim.
Well, when I read this series of new laws, Bill, and I envisioned them, how are companies and how you guide them toward the compliance, I was immediately reminded of one of my favorite movies in which this Irish priest was hearing confession and his parishioner was asking forgiveness for some sin of gossiping. And part of the penance given to her was that she was going home, go to her apartment, go up to the roof with a pillow and a knife, gut the pillow and watch the feathers fly and come right back. She did exactly as Father said. She asked whether she was forgiven, and the priest said, not quite yet. He said, now I want you to go back and collect all those feathers that were released and bring them back here, and then you'll have forgiveness. And certainly she explained that she couldn't do that because the wind had scattered the feathers to all four corners of the neighborhood. And he said, precisely, that is gossip. And when I read these laws, Bill, I immediately thought of that scene, because to go back and recollect every bit of data that we've placed out on the internet, from every time I bought a shoe to an Amazon purchase to this, that, and the other thing, those are all feathers. How can any company or entity go back and collect all of those things and get them back into the pillowcase? Can't be done in my mind. So we need to put many of them back in order to be compliant, but true compliance, true being forgotten, not going to happen.
Yeah. But by the way, there's a couple comments on the screen here from Mike, and Mike, let me get a couple of more slides into it, and then we can talk about your comments. I think they're great, but a couple more slides, and then we'll be able to get into it. So let's talk about one of the possible solutions, which is something called retroactive remediation. And this actually was posed to me by one of the Gartner analysts a while ago. And I actually hadn't heard about it, but really, retroactive remediation when it comes to the right to be forgotten, you know, they look at it this way, and I think this is actually pretty interesting. You know, you get a right to be forgotten request, and you immediately go to all the active systems and you delete the information, including archives. But archives are, you know, you can individually find and access and delete files, so that's great. But what do you do with backups? The idea is this idea of retroactive remediation. What does that mean? So let me give you a pictorial here. A data subject requests that all PII be deleted. That goes, you know, into the data protection officer at the company holding the data. The DPO, you know, asks IT to go look for the data. So IT, you know, goes and finds, you know, the PII and all the active systems, you know, and deletes it and documents what they're doing and all the neat processing stuff after that to ensure that you've done it right. But then, you know, IT then goes to look at the tapes, and the idea is they're not going to restore the tapes. They're going to make a master list of all of the right to be forgotten requests that have been storing up, and every time, or only when the IT goes back to actually restore a tape, they go to this master list and they say, okay, Bill Tolson asked to be deleted. We did that 6 months ago on all the active systems. I'm going to restore these tapes, maybe 3 tapes. First thing I got to do when I restore them is look for that PII, delete it, document it, and then restore that tape, you know, without the PII on it, and then put it back in its rotation. This actually, you know, works. It's not that much obviously better than that other graphic I showed you where you're doing this each and every time, but at least you're holding it until you have the requirement to actually access a tape. And by the way, the question, you know, comes up: who says nobody's accessing those tapes and not deleting PII? But, you know, we can get into that later. But that's retroactive remediation is one of those real possibilities to address this. Now, I've talked to various analysts in various of the analyst companies, and the idea of backup and the right to be forgotten, and what does that mean? And we've all talked about this is potentially a really big inflection point for the backup industry and the backup process. And I'll explain why here in a minute. Some of the potential options: don't back up at all, obviously not feasible, but you always got to throw that one in there just because somebody will bring it up. Keep backing up the same old way and deal with the cost and time, you know, if you get caught. You know, if a lawyer comes back and says, gee, my client wanted you to delete their PII and you couldn't certify to me that you got it off backup tapes, gee, I'm going to, sue you.
We refer to this as the asking for forgiveness rather than permission idea, which may work at the start, but not as we get older.
Not a good long-term strategy.
Yeah.
And then, you know, you could utilize retroactive remediation. I think that's a great short-term fix, but doesn't really fix the long-term problem of the cost and the time of going back and doing those restores and deletions and you know, re-backups and these kinds of things. And I think in the long term, legally, this might be shot down if, again, you got the right lawyer in place to go after it. And then another potential one here is field level encryption, and I'll show that in a minute. And then lastly, you know, combining data archiving with backup.
I like this list, Bill. It's like a continuum of doing absolutely nothing and then the best practice at the end.
Yeah. I know we're running out of time, so I will spend a little time on 4 and 5 here before we finish up. But it is interesting stuff. Now, field level encryption is basically the idea that you will go in and anonymize PII attributes, and you know, your system automatically recognizes that in any given file, it knows it can recognize those pieces or those attributes of PII, and it can go in and anonymize it and encrypt it. And basically, what you do is, you know, you get a request for deletion. You you either go to the active systems and delete everything, or you simply delete that specific encryption key, and all of a sudden that PII is unrecoverable and it's gone. Now, obviously, the issue with this is the complexity in that, you know, for a big company with millions or hundreds of millions of data subjects PII, you obviously have to have a different encryption key for each data subject, much less the logic behind it to use those keys and everything else. I mean, technically, it's an interesting case. It might be, at least in the short term, pretty complex.
This is where the state of the art is going, though, Bill.
Yeah. And then the other one is this idea of archiving and backup. And I talked to Gartner, and I talked to a couple of analysts as well about this, other analysts, companies. And the idea is that, you know, because of that inflection point, companies might start moving away from backing up at least files, but you know, targeting, you know, operating systems and you know, log files and all of those things as a backup target, but actually archiving all of the other files, you know, whether they contain PII in them or not, but just start archiving this stuff and put a retention policy on it. And if they're in an archive, then you can actually access those individual files. Like I said in the, you know, I was talking about retroactive remediation, you know, file by file basis, you can go in and delete them or anonymize them or do whatever you want. But the idea is that we're reaching a point where just blindly backing up whole enterprises is going to be too costly because of these right to erasure requests.
Right. And this would eliminate that need to go per repository search for each
exactly. Yeah.
Talk about that. Exactly. At the end of the day, this is the cost-effective math.
So let's save a little bit of time for questions, but in summary, you know, data privacy is quickly becoming an accepted human right, and I think, you know, around much of the world, and we're going to have to deal with it. You know, the possible scenarios I've talked about, none of them have been blessed, obviously, by the authorities. So we're just going to have to keep your eyes on them. It really comes down to, at this point in time, you know, a company IT guy, you know, what do you do? I once had a lawyer, a corporate lawyer, tell me, if in doubt, go talk to your corporate lawyer, even your external counsel, and get a written opinion, because that's your personal insurance policy. You know, then it's the lawyer's issue, not yours. So get direction from the lawyers, and that's always a good idea. And then the question of backups, it'll eventually be addressed by authorities, but you know, you got to keep an eye out as to what if and when a new precedent is set and what that precedent is. So with that, Sharon, I'll turn it back over to you.
Did you want to address the questions that came in?
Well, yeah, Mike had a couple of good ones.
Yeah, let's pick the hardest one and give it to Bill.
Okay. Yeah, one of Mike's comments was EU regulatory activity. Basically, for instance, anti-compliance investigations can mandate data retention for long periods of time. Yeah, no, I mean, there are the provisions that say, you know, compliance or legal situations, you know, basically override any right to be forgotten for whatever period of time, you know, that goes for.
This is one point where California did a better job, Bill, because the look back period is 1 year prior.
Yeah.
And like I said, each new successive law gets just a little bit better.
That was the look back provision of the CCPA. So
yeah.
very few people actually realized in early 2019 they were actually under requirements from CCPA to be doing certain stuff going a year back from when it became active, which was January 1st, 2020. Obviously, nobody was caught up on that. But Mike had another comment as well. He said just to note that the French GDPR regulatory authority, the FNIL, has clearly stated that organizations don't have to delete backups when complying with the right to erasure, and absolutely. But other country data protection authorities have not addressed it. And like Jim said earlier on, each one has authority within their country, and they weirdly, or maybe not so weirdly, interpret the GDPR differently. So France has addressed that, but the other 26 countries, I think, have not. Let's see, and then Mike had a last comment, but they must clearly explain to the data subject, absolutely, that backups will be kept for a specific length of time, and this is what the process would be, the idea of retroactive remediation. So yeah, very, very good points. I think we have, 3 more minutes, Sharon? Do you have a couple more?
Yeah, we can take another question. You mentioned the concept of new privacy laws potentially adding the idea of data fiduciaries. What does that mean?
Do you want to tackle that, Jim, or do you want me to?
Sure. So a fiduciary is a special legal relationship. A fiduciary looks out for your interests. Like if you're partners in a company, your co-partners are your fiduciaries. They're legally obliged to look out for your interests to some level or not. That is a high responsibility compared to a relationship where you leave something like a bailment. If you leave your car with the car check, that's not as high a level of care as a fiduciary. A fiduciary has a special legal relationship where essentially they're looking out for your interests, and it requires a lot more activity as a fiduciary.
Well, and there's a lot of kind of gray area in there, and I'm sure there'll be a lot of litigation around. Well, how did you determine this was in the data subject's best interest, or why didn't you? So
yeah, and the competing interests too, Bill.
Yeah,
the company has their own obligations to adjust marketing things and other things that PII is useful for. But now they're being asked in the fiduciary situations to serve two masters.
Yeah. Sharon, do we have time for another one?
Yes, we do. Well, we'll have to be real quick answer though.
Okay.
One of the slides on ransomware posed the question of how these would affect companies under GDPR and CCPA. How would one guard against this?
Let's take the example, Bill. Let's use the example.
That's really interesting, and I think I might have touched on it, but I think I went over it very quickly. The idea of encrypting your data before you put it up in a repository or in the cloud, and then the ransomware comes in, encrypts the encrypted data, leaves you the little nasty note and copies the data over. Yes, you don't have any way to address the encryption. So yeah, you still can't get access to your system. But the fact that you encrypted it first means the stuff that they copied and unencrypt, it's still encrypted with your encryption keys, so they can't put it out on the internet.
They can't use it.
And you don't have a liability on the privacy laws for that.
Yeah, the law firm in LA that represented major stars, Madonna, Bruce Springsteen, Elton John, when their information is leaked, if it's encrypted, no harm, no foul, right?
Yeah, because there's, I think at least in the legal industry, there's a precedent, several of them, that basically said, and I think in some of the privacy laws too, but the precedent was if data is stolen, or no, it was actually a different precedent. The encryption data was encrypted by an employee, and the employee left, and then later there's litigation, and the legal hold grabs up this encrypted data, but you can't unencrypt it because the individual employee left and took the encryption key with them. To the judge and to the court, that is spoliated data. That data has been destroyed because it cannot be unencrypted. Yeah. Therefore, you allowed data to be destroyed, even though it was inadvertent. Same with the privacy laws, and I've written about this before, and I've had a lot of comments on it. If your data is encrypted, did a breach happen? Right. Even if they accessed it and the encryption keys weren't even on your system, if they accessed your encrypted data and they have no possibility of unencrypted it, did a breach happen? And most people have said no, a breach did not happen. And your requirements to do the breach notification to all of your millions of customers does not trigger.
Big takeaway is field encrypt your data and then combine your data and backup and archives.
Yep.
All right, so we're a few minutes over. So I want to thank you guys for a very information-rich webinar today. It's been great. So just want to let our attendees know that this concludes our webinar for today. And if you have questions after the conclusion of this webinar, you can send them to info@archive360.com. A link to the recording and the slides will be sent out to all attendees at the ends of the webinar. And we will also post them on the website. And please stay connected to us, as we will have more informative webinars like this throughout the year. With that, I'd like to thank everyone for staying with us to the end of the webinar and wish everyone a great day. Thank you, everyone.
Thanks, everyone.
Thanks, everyone.